The Supreme Court decision in the case of People of the Philippines versus CYNTHIA, MORENO, and others. The right to speedy disposition of cases is provided for in Section 16, Article 3 of the 1987 Constitution. In determining whether the right to speedy disposition of cases has been violated, the following guidelines in Kagang versus Sandiganbayan must be considered. First, the right to speedy disposition of cases is different from the right to speedy trial. While the rationale for both rights is the same, the right to speedy trial may only be invoked in criminal prosecutions against courts of law. The right to speedy disposition of cases, however, may be invoked before any tribunal, whether judicial or quasi-judicial. What is important is that the accused may already be prejudiced by the proceeding for the right to speedy disposition of cases to be invoked. Second, a case is deemed initiated upon the filing of a formal complaint prior to a conduct of a preliminary investigation. This court acknowledges, however, that the Ombudsman should set reasonable periods for preliminary investigation, with due regard to the complexities and nuances of each case. Delays beyond this period will be taken against the prosecution. The period taken for fact-finding investigations prior to the filing of the formal complaint shall not be included in the determination of whether there has been an inordinate delay. Third, courts must first determine which party carries the burden of proof. If the right is invoked within the given time periods contained in current Supreme Court resolutions and circulars, and the time periods that will be promulgated by the Office of the Ombudsman, the defense has the burden of proving that the right was justifiably invoked. If the delay occurs beyond the given time period and the right is invoked, the prosecution has the burden of justifying the delay. If the defense has the burden of proof, it must prove first whether the case is motivated by malice or clearly only politically motivated and is attended by utter lack of evidence. And second, that the defense did not contribute to the delay. Once the burden of proof shifts to the prosecution must prove first that it followed the prescribed procedure in the conduct of preliminary investigation and in the prosecution of the case. Second, that the complexity of the issues and the volume of evidence made the delay inevitable. And third, that no prejudice was suffered by the accused as a result of the delay. Fourth, determination of the length of delay is never mechanical. Courts must consider the entire context of the case, from the amount of evidence to be weighed to the simplicity or complexity of the issues raised. An exception to this rule is if there is an allegation that the prosecution of the case was solely motivated by malice, such as when the case is politically motivated or when there is continued prosecution despite utter lack of evidence. Malicious intent may be gauged from the behavior of the prosecution throughout the proceedings. If malicious prosecution is properly alleged and substantially proven, the case would automatically be dismissed without need of further analysis of the delay. Another exception would be the waiver of the accused to the right to speedy disposition of cases or the right to speedy trial. If it can be proven that the accused acquiesced to the delay, the constitutional right can no longer be invoked. In all cases of dismissals due to inordinate delay, the causes of the delays must be properly laid out and discussed by the relevant court. Fifth, the right to speedy disposition of cases or the right to speedy trial must be timely raised. The respondent or the accused must file the appropriate motion upon the lapse of the statutory or procedural periods. Otherwise, they are deemed to have waived their right to speedy disposition of cases.